In this lecture, topic 12, lecture 2, we're going to take a look at. So the Eighth Amendment reads, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. So the question is what constitutes cruel and unusual punishment? What do these words mean? Well, if you think back to early in the semester when we did our initial worksheet or project applying the different legalism, literalism, originalism, polling jurisdictions, etc. Remember, that case was about a teen who was sentenced to a public hanging and whether or not that constitutes cruel and unusual punishment. And what these words mean and how you determine whether or not a punishment is cruel and unusual really depends on the perspective that you use to apply your interpretation of the Eighth Amendment. And so what standard might we use to determine whether a punishment is cruel or unusual? And as we're going to find that in general, the standard that the court uses is consideration of proportionality. In other words, does the punishment fit the crime? So let's take a look. So the court, not surprisingly, is divided on what constitutes cruel and unusual punishment. And a good example comes from the case Graham versus Florida from 2010. This is a case about Terrence Graham. He's on probation. He's a minor. He's arrested for committing 2 robberies. It violates his probation. The judge sentences him to life in prison, and in Florida, that comes with the penalty of no parole. And so he is sentenced to life without the possibility of parole. And the question comes before the court about whether or not sentencing a teen to life without the possibility of parole is cruel and unusual punishment. And the court majority finds that this punishment does violate the Eighth, and that the standard that they use revolves around proportionality. They basically say that the punishment should fit the crime. And in this case, they felt that the punishment was grossly disproportionate to the crime. And they conclude that no juvenile can be sentenced to life without parole for a non-capital offense. Not all in the court agreed that this, in fact, constitutes cruel and unusual punishment. Thomas says that the Supreme Court does not hold a special moral authority to determine what is and is not cruel and unusual. And Roberts, argues that it should be case by case, that it's not punishing a teen to life without the possibility of parole is not cruel as a class. And in fact, recently, the Supreme Court has kind of walked back and made allowances for punishing a teen to a life imprisonment. So, as you're going to read in your textbook, proportionality as a standard has a big impact on the court thinking about the cruel and unusual provision of the Eighth Amendment. But what about the punishment of death? Does execution constitute cruel and unusual punishment? Since 1947, the court has held that the death penalty is inherently neither cruel nor unusual. And we know that because states in the United States, as well as the federal government, use execution as a form of punishment. So we know that execution, it does not violate the Eighth Amendment. The reason that they've ruled that way is because of the intent of the framers. They argue that the death penalty was in use at the time of the writing of the Bill of Rights, so that if the death penalty was used, then that they could assume that the death penalty was not considered cruel or unusual. Also, they look towards the due process clause of the Fifth Amendment. The due process clause of the Fifth and the 14th says that life cannot be taken away without due process of law. However, if due process of law is followed, then life can be taken by the state. Still, there's efforts continue to eliminate due process or the death penalty, on due process grounds. So let's look at 2 of the famous cases dealing with the question that comes before the court regarding whether or not the death penalty constitutes cruel and unusual punishment. So in a moment, we're going to take a look at the 2 cases that are most important for understanding the court's approach to the death penalty. We're going to be taking a look at the Furman case, and then we're going to be taking a look at the Gregg case. But before we look at that, I just wanted to show you the number of executions that take place currently in the United States so that you get a sense of sort of really quite how infrequent the use of the death penalty is in the United States, and some of the trends that we've seen with the death penalty. Now, when we look at the Furman case, and as you read in your textbook, that in Furman in 1972, the court rules that the way that the death penalty is currently being used is unconstitutional, but with changes to the way that the death penalty is imposed, that it could be used again. So they did not rule like that that the death penalty is inherently cruel and unusual. They just said that the way it was being used in the 1972 in the Furman case, that constituted cruel and unusual punishment. And so you'll note that there was a moratorium on the use of the death penalty in the United States from like 1972 until the early 1980s. There were very few executions in the United States. And you're going to see that's because states started changing the way that they implemented the death penalty as a part of sentencing, and the types of offenses that were death penalty eligible, that they had to make changes in light of the ruling in Furman. But then we see that the use of the death penalty increases quite significantly in the United States, nearly 100 in 1999. And that's a reflection of sort of crime trends in the United States, that we had a rise in crime in the United States in the 1980s and 90s. Bill Clinton, with his omnibus crime bill, made significant changes to the use of the death penalty, and a lot of those were adopted by states. But since then, the use of the death penalty has really reduced in the United States. And so you see that, from 15 to 6 to 20, you really see death penalties in the low to mid 20s executions. And so it kind of shows you the trend. So when we're thinking about the future of the death penalty, it's likely that the death penalty will be considered not a violation of the Eighth Amendment, but it also just might be a penalty that grows increasingly infrequent in the United States. For many years, those opposed to the death penalty try to get the Supreme Court to hear a case that rules that the death penalty does in fact violate the Eighth Amendment. And that case comes to the Supreme Court in Furman v. Georgia. Furman v. Georgia is a case about William Furman. He's a black man. He is burglarizing a private home. A family member discovers him, the father of five, as noted there. Furman said he was carrying a gun and that he was trying to flee. Once he was discovered during the burglary, the gun goes off accidentally and kills the resident of the home. He's convicted of murder and sentenced to death, and the jury is the one who determines the death penalty. And so the question comes to the court about whether or not the death penalty is cruel and unusual punishment. And the NAACP Legal Defense Fund presents a lot of evidence saying that the way that the death penalty is imposed in the United States is arbitrary, capricious. It's sort of like they mention in the textbook that some of the justices feel as if getting the death penalty is just like so random. It's like getting struck by lightning. And so in one state you could commit an offense and you get the death penalty, in another you wouldn't. Two people who committed the same crime and found guilty, one would get the death penalty, the other would not. But most importantly, that there seemed to be a lot of evidence to support the racial bias in the use of the death penalty. The Legal Defense Fund presented a lot of evidence saying that people who get the death penalty, that it depends on the race of the perpetrator and the race of the victim, and that a black person convicted of killing a white person is much more likely to get the death penalty than a white person killing a white person or a white person killing a black person. And so it's when a black person kills a white person that seems to be the person who gets the death penalty. And so it seems like racial bias plays a large role in the arbitrariness and the racial bias of the implementation of the sentence of death. And the Supreme Court in Furman v. Georgia agrees with the Legal Defense Fund of the NAACP. In Furman, the Supreme Court says that as currently practiced, the death penalty is cruel and unusual punishment. There were 3 justices that said that, but and so they had a plurality of justices and you can read about this in the textbook. It's like the longest number of opinions that's written, pages of opinions that's written, is in the Furman case. That they said that with some changes, though, the death penalty could be unconstitutional. Only 2 justices said that the death penalty was unconstitutional in all circumstances. In other words, that it was inherently unconstitutional. Many were concerned with the arbitrary nature of the death penalty, and that they felt that that we should defer. The dissenters felt that we should defer to the state legislatures and let them determine what constitutes the death penalty. But the 5 said no, that it's too arbitrary and that the arbitrariness needs to be remedied. And if changes are made to determine that certain kinds of offenses are going to be death penalty eligible, and that we had a process in place that was less arbitrary and less riddled with racial bias, that if those changes were made, then the death penalty could, in fact, be used again. So following Furman, states made changes to the way that they imposed the death penalty as a sentence. And Georgia was one of the states that did that, and that kind of brings us to the Gregg v. Georgia case. One of the major changes that states made is that they broke a trial that dealt with the death penalty into 2. And so that it was known as a bifurcated trial, so that there would be a guilt phase of the trial and a penalty phase for the trial. And then so a person would be found guilty of a charge, and then there would be another phase of the trial where the jury would determine whether or not the person should be sentenced to death. And in the penalty phase, the defense was able to come and present mitigating factors, such as saying that they shouldn't get the death penalty, the age, chance for rehabilitation, psychological makeup, and the prosecutor would, present aggravating factors, saying that there were that this crime was of, such great magnitude or used, a great amount of violence, that the person should be subject to the death penalty. Other changes that states made was saying that only certain offenses were death penalty eligible. And so if you committed a murder during the commission of a felony, that would be a death penalty eligible case. Killing of a judicial officer, a crime that was outrageously vile, etc. And then finally, while the jury decides death, in light of these rules, that the Georgia Supreme Court, in this case, reviews all jury determinations of death. And so Georgia tried to coming out of Furman, they were like, well, let's try to make the imposition of the death penalty less arbitrary, follow more rules of due process, and have a check on the decision of the jury. And so that brings us to the Gregg case. The facts of the case are, just kind of horrible. Troy Gregg, his friends are hitchhiking in Florida. They're picked up by drivers of a car. The drivers are later found dead in a ditch. And then Gregg is ID'd as the assailant. He is convicted of murder and he is sentenced to death. So the question that comes before the court in Gregg v. Georgia is, does the imposition of the death penalty for the crime of murder under Georgia's law violate the 8th and 14th Amendment? And in a 7-2 decision, the court says that the death penalty does not violate the 8th Amendment or the 14th Amendment. That they, again, go back to, the historical long history of the use of the death penalty in the United States. This history and the precedent strongly support the notion that the death penalty does not per se violate the 8th and 14th Amendment. Public opinion supports the use of the death penalty, and state legislatures want to use it, so sort of deferring to the states, the police power of the states, and that the changes were made, as was in the case of Georgia, addressing the concerns that were raised in Furman, and as such that moving forward, if states make these changes, making the implementation of the sentence of death more in accordance with the due process of law, it is allowable. Well, post Gregg, it seems like the question is answered. The death penalty does not violate the 8th Amendment. Still, opposition persists, and there have been some victories in narrowing the scope of the death penalty, which you'll read about in the textbook. there are unconstitutional uses of the death penalty. You cannot execute somebody that for a crime that they committed as a juvenile, so that is unconstitutional. You cannot execute somebody who is mentally retarded or has a low IQ. That is unconstitutional. You also cannot use the death penalty for non-homicide offenses like child rape. That's a question that came to the court. So what's the future of the death penalty? Well, I would, at least in our lifetime, it's incredibly unlikely that the Supreme Court will rule that the death penalty is inherently unconstitutional. But we also see, as I mentioned before, a trend away from the use of the death penalty. So while it may still remain as a constitutional sentence, it may be this type of sentence that is imposed with growing infrequency. All right, made it through. Thanks for listening all semester long. I appreciate your time and attention.